Hello guys, and welcome to another episode of our civil litigation mock trial course by the Dear Court Daniel School of Law. On today's episode, we are talking about how to draft the statement of defense, right? In this class, I will teach you how to draft the statement of defense and the counterclaim. Right, but we are talking about the statement of defense, basically. Now in last class we talked about how to draft the statement of claim. And I walked you down the process, basically, from the heading of the court to the suit number to the parties to, the name, that statement of claim, to the first set of paragraph, which ought to be what is known as the matters of inducement, and then to the body of the statement of claim, then the relief, then the date, then signature, and for service on. Simple. You see? And I told you when I was teaching you the body, I told you that there are certain rules that you ought to abide by. What are those rules? You should make sure that your statement of claim is in paragraphs, and one paragraph should have a specific information. You should make sure that you seldomly use pronouns. You should make sure that you have a chronological flow of thoughts from the beginning of the whole incident to where we currently are today. These are things that I had given you proper explanation on in the last class where I talked about the statement of claim. I also let you understand that pleadings is one of the very important areas in the civil litigation exam for the Nigerian law school. You can't say you want to pass the Nigerian law school civil litigation and not know how to draft pleadings. It is extremely important. Do you understand that? I also talked about some of the other important topics, but emphasized how important the draft of pleadings are. Right? I told you that there are three types of pleadings: the statement of claim, the statement of defense, and the reply. And I talked about the time frame for each of these. Not only have I spoken about this in our draft class, I prepared about 20-something videos in our course, right, where I discussed all these things on pleadings alone. Right? The whole course already has over 200 videos from the beginning of civil litigation to where we currently are. So this is just to let you understand that, we're really doing a lot. Now, going to our class for today, because these are things that I already said in the last class, I would limit what I would say in this class. So please, if you have not watched the video on statement of claim, I will put it in the description of this video on YouTube, because I intend to release this on YouTube. But I would also put it on the website in the course. So if you have not watched this, please just go to the preceding video, the video before this one, and you'll be able to see it there, right? The class before this one, you'll be able to see it there. The reason is, I don't want to keep saying things that I already said in the last video, right? So that I save your time. So for example, now we are talking about the heading of the court. You will see that it is the same heading as the last video, because I wanted this to be a response to that statement of claim. Do you understand? I don't want to have another statement of defense that has different parties and all that. No, I want to have a response to that statement of claim, so that not just for the sake of your bar finance, but for the sake of practice, you would know how to draft and respond to a statement of claim as the defense counsel. Do you understand my point? So if I use different parties, different scenarios all over again, then you wouldn't know how to respond. The element of response, ability to respond to especially key issues that has been raised in the statement of claim, would be missing. That is the basic reason why I'm using the same thing. So, for example, it is still in the same High Court of Lagos. I told you already that I have a class on jurisdiction and how to commence actions in the High Court, Module 5, then jurisdiction, Module 2, that will let you understand what courts for you to bring an action to. Right, whether the one at Abuja, the one in Lagos, and all that, we already have discussed that. And I told you that if it's in Abuja, it's going to be High Court of the Federal Capital Territory, Abuja. Right? Then we talked about the suit number. We already talked about this. It has to be in all the processes. Then between the parties, I already talked about representative action and why I decided to use an example of representative action for you, and also the defendant being the company. So you should already be familiar with what we are talking about here, suing for themselves and on behalf of. I already explained it in our class for statement of claim, and I told you that if you want to learn how to draft the party section very well, draft par excellence, then you should go and listen to the about 20 something classes that we had for parties to an action module 3 in our course. In our course, we already have parties to an action module 3, and that is going to guide you on how to properly draft the parties section when you find it in exam. If it's a child, how do you draft? If it's a business name, how do you draft? If it's a company, how do you draft? If it's a representative action, as in this case, how do you draft? These are questions that we already have answered in the 20-something set of classes that we uploaded for the Module 3 parties to a civil action. Do you understand? So I think that already answers that. Don't forget that you add the description, claimant and defendant. You are the high court, so it's supposed to be claimant and defendant. You seldomly use plaintiff at the high court. It is claimant and defendant. Please take note of that. Now, the heading, you have the statement of defense and counterclaim. Statement of defense and counterclaim. When we were drafting that of the statement of claim, what was the heading? Statement of claim. Now that we are talking about the statement of defense, note that it is not every statement of defense that will be accompanied by a counterclaim. Please note that. But in this case, we have statement of defense and counterclaim because I want to teach you how to draft your statement of defense, right? When it also would have a counterclaim. Do you understand? So some other people's drafting style will be to write just statement of defense. Then when they now get to the point of the counterclaim, they just write counterclaim. But I think it's better to write statement of defense and counterclaim so that on first glance of the document, you would know that there's a counterclaim attached to this. Don't forget the time frame, for which you are supposed to file your statement of defense within 42 days of the service of the statement of claim and the originating process on you. Do you understand that? Now that we know that, okay, the heading is going to be statement of defense and counterclaim, what is the next thing? The next thing is what is known as the general traverse. The general traverse. I already explained it in my course when we're talking about pleadings, what the general traverse is. The general traverse, save and accept as herein expressly admitted. The defendant denies each and every allegation of fact contained in the statement of claim as if same were set out and traversed seriatim. That is the general traverse. What is the implication of this general traverse? Why is it expected to be in your statement of defense? These are questions I already answered while teaching this thing in the course. So I'm not going to go back and teach it over and over again. So today's class, we are learning drafting. And while we are talking about the draft of the statement of defense, you need to understand that the first thing that should come after your heading, the first thing should be your general traverse. If it is not there, you are failing. If it is not there, go to your externship. Go to any law firm for your internship, for those who are not in law school. Go to any law firm for your internship and pick up a statement of defense and tell me that you did not see general traverse there. It's not possible. It's so customary that you are expected to cram it. Save and accept as in hearing after expressly admitted. But in this case, it's just save and accept as hearing after, there's no after there, as hearing expressly admitted, right? So I personally would say save and accept as in hearing after expressly admitted. That's how I like drafting it. But some will say as in hearing expressly admitted. Right? I already told you the difference between all these things, so I'm not rehashing it. I'm just telling you that make sure that it is there. Then your first paragraph. Now, the first set of paragraphs that you're supposed to have is there a matter of inducement where you are now going to start explaining who the claimant is, explaining who the defendant is. Do we have that in a statement of defense? And our answer, ladies and gentlemen, is no. Why? Because what you do in your statement of defense is that you are either admitting or you are denying. What are the types of traverse or denial that we have? Ladies and gentlemen, I already taught all these things. We have so many different types of traverse that are already discussed in our class. That's our module 9 on pleadings. Like, there were a lot of classes for that already. Right? So we talked about the fact that there is general traverse. General traverse is the first thing that you do. Then we talked about the fact that there is specific traverse where you deny specifically. Then we talked about the negative, pregnant, or evasive traverse. We talked about the traverse where an allegation is partly false and partly true. We talked about traverse where the defendant is not in a position to admit or deny an allegation. These are different types of traverse that we have already talked about and the implication of each of them. So I'm not going to be rehashing them here. What will I do here? I will just show you how they come to play vis-a-vis the statement of claim that we already learned how to draft earlier. So the first paragraph here tells us what? It tells us that the defendant admits paragraph 1 and paragraph 2 of the statement of claim. Please, who can remind us? I know that you cannot respond now, but I want you to respond mentally. Who can remind us what is paragraph 1 and paragraph 2 of our statement of claim? Who can remind us? Those are what is known as the matters of inducement, where we said, oh, the claimant are members of so and so family, of so and so area, who reside at so and so place, suing for themselves and on behalf of so and so family within the jurisdiction of this court. All those things like that is inside that paragraph 1. Paragraph 2, the defendant is a limited liability company that carries on what kind of business and has its office address where and within the jurisdiction of this court. Now, when I was teaching you pleadings, I can remember that I told you that one of the things that you do not need to traverse, that means to deny. Traverse means to deny, right? So one of the things you do not need to deny are the matters of inducement, except they are manifestly untrue. So why are you denying? Is the claimant, are they not members of so family? Why are you denying that? Do you get? Except it's manifestly untrue. Do you understand what I mean? So now moving on. So you can say that the first paragraph here is not matter of inducement. The first paragraph is I am admitting paragraph 1 and paragraph 2. Why? Because these are matters of inducement that need not be denied except they are manifestly untrue. Do you get the point? Now, that is the first thing that you have. Please note that you don't say paragraph 1 and then begin to say save and accept until hearing after expressly admitted. That's a general traverse. A general traverse comes up before you even start listing your paragraphs. Don't forget that the rules of drafting the statement of claim still applies here. You do not, draft your statement of defense like you are narrating a novel. No. Here you have to put it in paragraph, and it also has to be in a chronological order. So you will see how chronological it is and how it makes sense. So the first paragraph now is admitting paragraph 1 and paragraph 2. Now the second paragraph is denying paragraph 3, paragraph 4, paragraph 5, paragraph 6, and paragraph 7 of the statement of claim, and then he puts the claimant in the strictest proof thereof. Can you see the reason why it is important that when you are drafting your statement of claim, you should make sure that there is only one important information per paragraph? Why? So that when the defendant wants to traverse your averments, which means that if the defendant wants to deny any paragraph, he can easily do that. Imagine that you have mumbo-jumboed like 5 different information in one paragraph. Now the defendant wants to deny. But as the defendant wants to deny one part of that paragraph, he now remembers that, oh, this other part is true. But this one too is lie. But this one too, do you get? So instead, put one information per paragraph so that when the defendant wants to deny, the defendant can then pick each of the paragraph and deny them one after the other. So the defendant denies paragraph 3, paragraph 4, paragraph 5, paragraph 6, and paragraph 7 of the statement of claim and puts the claimant on the strictest proof thereof. Do you see that? So what was the first thing that the defendant did here? After his general traverse, the first paragraph, he looked at the statement of claim and picked the part that was true and the part that we would like to admit. Now, I have taught you what is the implication of the defendant making this admission. Where the defendant has admitted, what is the implication? I already taught that in our class. The implication is that it needs no further proof. The defendant has admitted, that's the end. Do you understand that? Now, to move on, you have admitted paragraph 1 and paragraph 2 of the statement of claim. That is the first paragraph. The second paragraph is where you now pick those paragraphs of the statement of claim that you know you want to categorically deny. Categorically, then you point those paragraphs out and then you deny it. Now, the defendant avers that the land was granted to it by the Lagos State government by a certificate of occupancy number 3758 dated so and so. Now, don't forget that when we were talking about our statement of claim, and you can see the reason I said, let me continue the flow of that statement of claim so that you can see how to deny and how to make your averment. Don't forget that this family now, they said that they got their own title from where? From the first settlers of the family, right? That's on that land, right? And then he was able to show the traditional history of how it's currently got to the people now. And then he now told us, I think it was paragraph 5, he now told us that, then the defendant came from nowhere and entered his land. And that the defendant is relying on a certificate of occupancy that the government has given the defendant. And that he knows, that is the family. The family knows that the government has not acquired this land. Also, that they have not paid any compensation. Those are paragraphs 6, 7, and 8 thereabout of the statement of claim. So you can see that I still remember what is in the statement of claim because they were outlined in each paragraph and they have information that we are looking for. Now the defendant has picked each of those paragraphs and has denied them, putting the plaintiff, that is the claimant in this case, on the strictest proof thereof. Now he is now making his own averment that, my lord, the defendant avers that the land was granted to it by the Lagos State government. Therefore, he is pleading his own certificate of occupancy again. Now, I can remember one time when I was drafting a statement of defense for my principal, that's the senior associate in my firm. And then, they had already pleaded certain documents. That is the statement of claim. They've already pleaded certain documents. And then I now had to ask him that, wait, since they have pleaded the document, it means that they are going to admit those documents by their witnesses, right? Why are we pleading these documents again? Don't forget that the statement of claim already pleaded the certificate of occupancy. So which means that same certificate of occupancy will be tendered in evidence, right? In proof of their case. Now, why are we pleading it? Since the court is already going to have the certificate of occupancy, we can just keep making reference to it. My boss told me that you are supposed to plead your own documents so that you can rely on your document. You don't know the kind of documents that the other party wants to bring. So you cannot be saying, I want to rely on the document that the other party is tendering. No. You bring your own document. You know the authenticity of your document. What if their document is altered to your detriment? Right? So don't rely on their document. Plead your own document. So now you can see that by paragraph 4 or paragraph 3 in this case, the defendant avers that the land was granted to it by the Lagos State government by a certificate of occupancy number so and so, dated so and so. So now he has pleaded his own document. And don't forget, like I said in the last class, do not say that, the certificate of occupancy is hereby pleaded and marked exhibit, blah, 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 or hereby attached, or is pleaded and shall be relied on at trial. All those things do not work here. Where do they work? In affidavits. Do you understand that? They work in affidavit. Go and do that in affidavit. Don't do it here in your pleadings. All you just need to do is state fact that makes reference to the document. That's all. State facts that make reference to the document. You are not going to say that this document, that is the certificate of occupancy, is hereby pleaded and shall be relied on at trial. No. To continue, the defendant further states that since the grant of the right of occupancy, it has used the western flank of the land close to its factory to depose waste from its farm. So now, he is now making his own averments that, since they gave me the certificate of occupancy, I have been using so and so to depose waste. And then paragraph 5, the court will at the trial be urged to dismiss the claimant's claim as it is baseless and bereft of substance. It is every statement of defense that they always say that the statement of claim is baseless and bereft of substance. They always literally write it in. I have drafted so many statements of defense, right? And also I've drafted so many statements of claim. And anytime I await the statement of defense that is to come by other parties, they will always state that, the statement of claim that we drafted is bereft of substance, is baseless, all those kind of things. Even when we are drafting our own statement of defense, we will say, their statement of claim is baseless. So that's like a paragraph that you should always keep in mind when you are drafting your statement of defense, right? So that you just tell the court, we would urge the court at trial to dismiss the claimant's claim as it is baseless and bereft of substance. Just put that in your head. That's basically what I'm saying. Now, you can see that's the end of the statement of claim. So normally you are supposed to put dated this dash day, then put your signature on one side, as you know, I've already taught you how to draft, then put for service on the other side. However, this statement of defense is accompanied with a counterclaim. And I already told you when and how we use a counterclaim. I have taught that in our course and I will not be rehashing it here over and over again. So let us just go straight to that counterclaim. Now, that's number 6 now, the defendant counterclaimant. You can see that the nomenclature has changed. What we were saying when we're drafting the statement of defense was the defendant avers, the defendant denies, the defendant admits. Now we've gotten to counterclaim now. We are no longer saying the defendant, we are now saying the defendant counterclaimant. That is what they want to see in your exam. Are you seeing the difference? You can see the way we admitted, the way we denied, the way we put the claimant on the strictest proof thereof, and then we now began to state our own position. Then the last paragraph, that our trial will urge the court to dismiss the claimant's suit as is baseless and bereft of substance. You can see that we walked through a process which I've taught you. Now we are coming to the counterclaim now, and the first thing that you should notice that changes is that the defendant is now a counterclaimant. So he is now a claimant in a counterclaim. So he has to state it. The defendant counterclaimant repeats all the averments in the statement of defense. Now, the same way, look at it. I want you to remember key things. The same way your general traverse is the first thing that comes in your statement of defense. Is the same way the defendant counterclaimant repeat all the averments in the statement of defense is the first thing that comes in your counterclaim. Do you understand that? Also, the last thing that should be in your statement of defense should be that at the trial, the court will be urged to what? To dismiss the claimant's claim as it is baseless and bereft of substance. That's the last thing that you put in your statement of defense. Are you following? I need you to follow. There are certain things that are known as customary. Your first thing, general traverse, right? Your last thing, which is the bereft of substance in your statement of claim. Now you now come to the counterclaim. Your first thing there being the defendant counterclaimant, repeat all the averments in the statement of defense. Now we move. The defendant counterclaimant states that the claimant and the defendant to the counterclaim entered upon the land. Now, the claimant and the defendant to the counterclaim, that is, you know who the defendant to the counterclaim is? The defendant to the counterclaim is now the main claimant, that is the family. Do you understand? So he is the claimant in the main claim, and now the defendant to the counterclaim. So when you are drafting, you have to make sure that you understand those references and use them properly. So now the defendant counterclaimant is averring that the claimant to the main claim and the defendant to the counterclaim entered upon the land covered by his own certificate of occupancy, right? Which is in possession of the counterclaimant, who that is him, the defendant counterclaimant, on so day and so day without permission of the counterclaim. So let us go back to the statement of claim. Can you remember what the statement of claim was saying? The family, they are saying that, oh, the defendant has entered my land. That is the company. Don't forget that the defendant here is the company. You can say that we have even forgotten that it's the company. Why? Because we have substituted their name, that is the company's name, for claimant and defendant. That is one of the rules of drafting, so that you don't repeat the company's name in the body of your pleadings. Now they are saying that the defendant, right, entered their land, right, and therefore they want to collect 10 million naira for general damages for trespass. Now in the counterclaim, now the defendants to the main claim and the counterclaimant in the counterclaim is now saying, oh my lord, see, we get certificate of occupancy, now we gone own the land. Now this family now can trespass on our land, so we say one counterclaim collect money for trespass. So we have two trespass claims here. We have the initial one from the statement of claim, where the family is saying this company has trespassed upon my land, and then we have in the counterclaim where the company is saying, no, it is this family that trespassed upon my land. Do you understand that? Let's read that line again. The defendant / counterclaimant states that the claimant and defendant to the counterclaim entered upon the land covered by a certificate of occupancy number so in possession of the counterclaimant, that's the company, on the so day and so day without the permission of the counterclaimant, right? That the defendant counterclaimant avers that the claimant / defendant to the counterclaim interrupted the activities of the counterclaimant on those occasions which resulted to the loss. So they are saying that, okay, we are producing something that, we already stated in the second averments for the statement of claim. So we know that the company is into production of some things. Now they are saying that when the claimants and the defendants to the counterclaim, when they came upon their land, that they disrupted most of the things that they were doing, the activities they were doing, their business, and therefore there is loss. So you can see that not only are they looking at the angle of trespass to collect money for trespassing, now they want to look at the angle of, we have acquired economic loss, basically, because of the actions of trespass committed by the family. That's what they are trying to prove here. Then we now go again, that the counterclaimant avers that he had to pay all its casual staff who turned out for work to dispose of farm waste on the land on those two occasions that the claimant defendant to the counterclaim entered the land and interrupted work. So here is further buttressing his point. Now, number 10, that's paragraph 10. Now, therefore, the counterclaimant / defendant or defendant / counterclaimant claims against the claimant / defendants to the counterclaim as follows. You can see how kind of clumsy it is, right? I believe it's kind of clumsy, but this is how it ought to be. So the defendant / counterclaimant claims from the claimant / defendant to the counterclaim as follows. And I hope you can see why it is like this. The person who brings an action is the claimant. The person who defends the action is the defendant. Now, what if that defendant now wants to institute another action against that claimant? Does it go to another court? No. He institutes the action in his statement of defense using what is known as a counterclaim. A counterclaim is a different action from the action of the original claimant. Right? So therefore, he is the defendant to the main action, but a counterclaimant. Therefore, another claimant in himself, while the original claimant is now a defendant to the counterclaim. This is why our relief clause, which we must know that when we are talking about the counterclaim, it must also have the requirement of a normal statement of claim. So you must have the introduction and every other thing, and as well you must have your relief sought, right? So therefore, the counterclaimant slash defendant claims against the claimant slash defendant to the counterclaim as follows: A declaration that the land situate at so place belongs to the counterclaimant slash defendant. Note that in the statement of claim, that was what they also claimed for, that the land belonged to the family, the claimant. Now, this one is saying that the court should make a declaration that it belongs to the defendant slash the counterclaimant. So you can see that the court has a lot of work to do here. Now, a declaration that the action of the claimant slash defendant to the counterclaim of entering the land situated at number so amounts to trespass, which is the same thing that the other family too they were asking for, that the actions of the defendant amounted to trespass, an order of perpetual injunction restraining the defendants by themselves, their agent, privies, and servants, or any other person claiming title through them from acting or further act of trespass on the land subject of this suit. Then we now talk about the sum of 20 million naira and the cost of the suit. So it is basically the same reliefs that the other party asks. It's just that for general damages here is 20 million, while general damages there was 10 million. Right? Then you have dated this dash day, then your signature as counsel. I already taught you how to draft that. The name of the counsel first, the firm of the counsel, who the counsel is representing, the address of the counsel, the email, and the phone number. And then we replicate that too for the other party. So for service on the claimant, CO of his counsel. CO means in charge of, just like through. Right, so in charge of their counsel, that is dear called Daniels and all that. Now note that the statement of defense, you don't need to serve it personally, right? The requirement of service personally is for the statement of claim. So the statement of defense can be served through the counsel. Please take note of that. When you are drafting your statement of claim, you serve it through the defendant himself. You can't serve it through the defendant's counsel except there is a motion for substituted service which must have been granted by the court. The order must have been granted by the court, right? So please take note of that. Very, very important. I've taught you how to also draft. Take note of this draft. And I think that this is a very beautiful point for us to end our class for a draft of statement of claim and statement of defense. So I believe that at this point, and one more thing that I need to add is that for this statement of defense, I need you to know that it is not frequently asked in exam. Why? Because you have to respond to something. Do you understand? For you to draft a proper statement of defense, you must be responding to a statement of claim. Because you must admit some parts, you must deny some parts, you must or could either admit or deny some parts. Do you understand? You could say that certain things are not within your knowledge. There are certain skills for that drafting of the statement of defense. That's why law schools seldomly ask it as a question in exam. However, the statement of claim is usually and frequently asked, which is why I paid more attention in teaching the statement of claim. Also, note that is not to say that the statement of defense has never been asked in exam. It has. But what they usually do is that they will scatter the statement of claim. They will unarrange it. They will give you a draft in exam, yes. A draft statement of claim. They will scatter all the things, unarrange everything, now tell you to redraft it. Redraft it. Don't worry. We are going to solve past questions. In each of these past questions, I will teach you, how all those things have been done in the past and how we can overcome each and every one of them. I hope that you've had a beautiful class. The only way I can tell you for sure, the only way for you to be able to become a master at drafting is when you begin to practice these things. So please solve more past questions, practice all over again, and I'm very sure you will do wonderfully well in your exams. So with that, I will see you in our next civil litigation class. Have a very wonderful day.